It allows islanders to make decisions on what they want for their future for such a time that they may not have capacity to do so. What we know is, with the great thing about living longer, is that we have a longer lifespan, but there's likelihood or there's a possibility that we might lose capacity at some stage during that time, and that could be for a short period of time or it could be for a longer period of time, depending what the condition is that's causing the lack of capacity. What this will allow islanders to do is to write a lasting power of attorney, which they can identify the people who they want to look after their affairs, financial affairs and assets, or their health and well-being issues for such a time that they may lose capacity in the future. The other key element is the ability for people to state advanced decisions to refuse treatment. So some people might not want certain treatments as they move into different elements of sort of losing capacity or having a lack of capacity, and they can specify what areas they would not want to receive treatment for. So for a few years now, we've been working on a policy which has come from the Safeguarding Board. It's a multi-agency policy, and the principles of that policy have been carried across into the new legislation. There's clarity about what a lack of capacity looks like. So if someone doesn't have capacity, what does that mean? How do we assess someone who doesn't have capacity? I think one of the key things is it starts with an assumption that people have capacity. So we make the initial assumption that people have capacity until such times that we have concerns about a specific decision, and so capacity decisions have to be time and decision specific. I couldn't, for example, be described as lacking capacity per se, but I might lack capacity in making decisions with a high value financial situation, whereas I might have full capacity in making decisions on lower levels of finances. If it was someone who had a mental health problem, we used to have a curatorship element of the mental health law, which allowed the Royal Court to appoint a curator to look after someone's finances. One of the big differences there is that under that legislation, the curator had to look to protect and look after someone's finances. What we do now is someone doesn't make a lasting power of attorney, but needs someone to support them with their finances, the Royal Court can appoint a delegate. And that delegate has got the responsibility to look after someone's affairs. If we take the finance and assets, they have to look after those, but they have to do it in their best interest. So it might not be that they're looking just to maintain the finances and the assets, but they're actually looking to provide people with the right support and care that they need in their best interest. There was no previous facility for islanders themselves. It had to come through a health and social care employee or a GP to identify the need for a capacity application. Now what can happen for a lasting power of attorney, myself as an islander can go on to gov.je, look for lasting power of attorney and complete that documentation with the person whom I wish, or the people that I wish, to have the power of attorney should I lose capacity at any time in the future. And I can complete that and submit that, and that goes through to State's Gref, and they then process the information and register the lasting powers of attorney. So it's an online system that allows people to make the applications on their own behalf with the support of the people that are going to be doing the attorney role. There's a number of safeguards within there. So if someone's got a delegate, that delegate has to return, make provision for estimating what's going to be required over the next period of time, over the next year, and they have to sort of return sort of documents and such like to the judicial gref, or not to the judicial gref, to the gref, identifying what has been spent and what is required. So there's those safeguards. The other thing I think is really important for people who don't have capacity is that we've got independent capacity advocates. So they're a body of people, there'll be an organisation who will be appointed by the Minister of Health to provide capacity advocacy, independent advocacy, so it's not a legal advocacy, to people who lack capacity, to make sure that their voice is heard and that they are appropriately sort of supported in whatever their care needs might be.